Another week wraps up. A full week of trial in one case, a full week of jury selection in another, motions being denied in one, and a new meaning to the attorney-client privilege. This is a weekly summary on Just Legal History, and I'm your host, Mike. I have been focused this week on the Nicolae Mui trial. You can see my other video on it. We've heard from over 30 witnesses in the case, from the different groups on the river that day, to the nurse, and then some of the police officers involved. The state has said that they plan to wrap up early Tuesday, and then the defense will start their case. Nick does plan to testify, so we'll see if he does that on Tuesday or Wednesday. It was interesting today because they had to use Spanish interpreters because some of the people in Mui's party spoke Spanish as their primary language. Nick is from Romania originally, and I think he will testify in English. So we await the continuation on that front. The Chad Daybell trial started this week, and the entire week was devoted to the jury selection. The goal was to find a pool of about 50 people who could serve on the trial, and then work on gaining it down to the 12 that will serve on the jury and the alternates. In the Delphi case, the motion for dismissal charges was dismissed by Gull as expected. The state also put in their response to the Franks hearing motion. The ironic part was about the cell phone technology. It normally is the state that is talking about how cell phone technology can pinpoint persons, but in this case they were arguing the opposite, in that the cell phones of other people could be anywhere. The second part of the motion reply dealt with the runes and whether or not any of the signs at the crime scene could indicate rune messages or not. The state was saying their expert was saying no. Now we await Gull's motion on the Franks hearing, along with her contempt hearing decision. Two trials that have been over for a bit showed up in the last 10 days. I didn't report on it last week, but Hannah Gutierrez's lawyer had asked for a new trial, but that judge denied the motion. The lawyer had talked about how Hannah had done everything she had been asked and was doing the right things, but the judge said she will be sentenced. And then a very similar thing happened in the Jennifer Crumbley case, except for one addition. Jennifer Crumbley asked that the judge to have her sentence be under house arrest, but do it at her attorney's guest house. Hence my bad joke about attorney-client privilege. I think that was denied too, and both Crumbleys await their sentencing. Another trial that had a little bit of movement was the Bryan Kohlberger trial in Idaho. We are still in the very early pre-trial stage, and it looks like there was a hearing to talk about the potential change to venues. The defense was trying to use the surveys to help gauge potential juries on if they've already made up their mind about Bryan's guilt or innocence. But at the same time, the criticism has been that the defense was trying to influence the potential jurors with that survey so that they could move the trial. Seems like another case where the judge seems to be getting angry with the defense counsel. I asked my friend about the role of being a defense counselor, and she said it's definitely hard. If you're doing your job, you're pretty much hated by everyone. You're hated by your client at times, the prosecutor, the judge, and the public in general. Much easier on that front to be the prosecutor. I don't know if it's something that I could do. Thank you for listening to a week ending on April 5th and the episode of Just Legal History. Go out and enjoy the weekend, but please do not do anything that would make me do an episode on you.